I'm parking right now.
What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks that the court would allow.
Okay. So maybe I don't understand something. And he was just driving and he didn't have a license. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
If you skip turning yourself in, the judge isn't joking, you will get a bench warrant with no bond. Well, this guy actually did turn himself in, bonded out, and now he's back in court, just not behind the wheel this time. We'll get to that case in a minute, and trust me, you don't want to miss it. There's a wild plot twist waiting at the end. But first, let me catch you up on someone I've been watching for a couple of years now, Jeffrey Bloom. And if that name doesn't ring a bell, don't worry, here's a clip from his arraignment on domestic violence charges to refresh your memory.
You will be held accountable.
You got it. Okay. All right, we're all set. Thank you.
Jeffrey Bloom is, well, let's just say he's a special kind of special. His long, chaotic saga is finally wrapping up, and today marks one of his last pre-trials before he heads off to face a jury. And judging by Judge Simpson's expression, yeah, he's definitely not shedding any tears about watching Bloom's case move on. Alright, let's dive in.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least
and
I'm
you
not.
said,
At least I'm not driving with a suspended license.
It's a little tough to crack jokes about driving on a suspended license when you've spent the last few years sitting in jail, Jeffrey. And honestly, I'm not sure where you thought the humor was. Especially when you're facing domestic violence charges, which are on a completely different, far more serious level than a simple suspended license.
2 times now I've let it go. Remember?
let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any, there's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why, Mr. Bernstein.
Which discovery referencing, Jeff?
Hospital report that Deputy Soyring says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Her transcripts. No, I still haven't received the transcripts
of what?
3-6. Remember, I asked for the transcripts from 3-6. I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney, tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professionals. So
If we're being honest here, Jeffrey isn't exactly working with a full deck. And yes, you heard that right. Jeffrey Bloom isn't just a raging alcoholic who can't keep his hands to himself, he also thinks he's a constitutional law expert. In his mind, he's somehow more qualified than every single public defender he's already fired.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing, and someone in my office kind of like, we did a transcription of it for Jeff, but I think what he wants me to request is an actual transcript, and I just didn't.
well, and so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff's 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right now?
Something that I want to state on record, Your Honor.
No, but what
can I do that?
you're obviously stating what somebody else said. I'm just
No.
trying to figure out where it's coming.
You said,
On the 24th of,
no, on 10-4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authenticity, and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be
Okay,
in
well,
regard to your
I'm
other
trying to-
matter because
I'm
this
trying to
didn't
put
start.
canons.
No, stop. This case didn't start until 10/18. So if you're referring
Okay, I'm
to a
past that.
record from another case,
Then I'm past that.
then you're past what?
I'm past the other case. Here we go. This is
I think Judge Simpson's face says everything you need to know. And if there's one thing that's always been true about Jeffrey Bloom, it's this: no man, especially not a judge, has ever been able to stop him from running his mouth.
Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental.
Yes.
Yeah,
Yes,
has
that was a
nothing to
motion
do
we
with-
filed.
No, but that has nothing to do with the case.
But I mentioned that on
And
other things you did that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear it.
going to, you don't want to hear, I don't. Because what
know.
you're saying is incorrect.
Okay,
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
there were other matters you did the same thing, Your Honor. I'm not
Goodbye.
contacting your
Goodbye.
commission.
Goodbye,
I'm not
Mr. Bloom.
contacting-
Goodbye. Thank you. Have a great day.
Like your horse.
Take care.
Where you're at. We'll contact the senior commission, sir.
Have fun.
Alright, that wraps up the first hearing, and honestly, I'm perfectly fine with him staying right where he is. If anyone besides Chili DeCastro deserves a long time out in jail, it's definitely Jeffrey Bloom. Now let's move on to our next hearing, where our viral defendant makes his grand return to court.
Court, Dion Webster Cox, appearing on behalf of Mr. Harris. How are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
Signed off on.
It is.
All right, then I don't need to address. I don't need
Thank
to
you.
address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there's several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what, at least as I'm to understand, is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it, and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and commonwealths that form up this great union.
Let me pause here and break down why this moment actually matters. Up until now, the defendant has been seriously misrepresenting the status of his driver's license, to the court, to the news, even to his own attorney. His whole defense rests on the idea that the court and the Secretary of State messed up the paperwork after a child support case, and that their procedural screw-up left his license suspended when he believed he'd done everything required to get it reinstated. But here's what Judge Simpson is pointing out, and it completely blows his argument apart. Even if everything had been handled perfectly on both sides, it wouldn't have changed a thing, because he never had a valid driver's license in any of the 50 states. So the entire "my license should have been unsuspended" defense? Yeah, it collapses instantly.
License, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, But that wasn't at all said. But it doesn't matter because he didn't have a license ever. There is also then, and you know, I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You covered a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th day. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing, and I'm in this last afternoon of driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines, between October of 2023 and the point in time of the May 15th hearing, was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. Then being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which for the way we handle things in this court would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID. I have the date.